Hello, everyone, and welcome. Today's HR chat session is background screenings. And with us today is Nick Daukas, Managing Partner of KardasLarson. Welcome, Nick.
Thank you, Michael. Welcome. And I am happy to introduce that along with me is Maribeth Martino from SSC. Maribeth is currently the Director of Background and Investigations Division of SSC and has been managing her division for over 10 years. Maribeth directs a team of investigative professionals responsible for researching and analyzing tens of thousands of candidates annually. Welcome, Maribeth.
Thank you. Yes, welcome.
All right. So real quick, our talking points that we're going to cover today are screening do's and don'ts, disclosure and authorization, basic search elements of a screening program, the impact of marijuana for employers, and what are the industry trends for small and mid-sized employers should be aware of. All right, well, let's kick it right off. So Maribeth, can you describe some of the basic do's and don'ts for small to mid-sized organizations when it comes to background screening?
Sure. Background screening is an extremely common practice for employers these days. And there was a survey that came out back in 2018 that HR.com and NAPBS conducted, which was reporting that 95% of employers say they're using one or more types of employment background screening services. So it's very common in today's environment, and there are some basics that are important to consider. So first things first is that you do need to get a signed disclosure and authorization form from your candidate. This is a legal requirement. The candidate does have a right to know about the investigation. So you definitely will want to be familiar with the federal background screening laws, such as the Fair Credit Reporting Act, which is the main law that governs what is known as consumer reports, which is another word for a background check report. So you want to be familiar with the federal level with the FCRA, and then also there are state laws that you should be familiar with where, especially where you do business and where your candidates are located. Beyond that, you would want to be responsible with your background check reports. Keep in mind that they are confidential. You want to make sure that you're properly securing them and disposing of them. So definitely keep that, be responsible with them, and also to have a background check policy that addresses the nature and scope of your background screening. So you don't just want to begin doing background checks without any notification, or you'll definitely want to make sure that you have some kind of policy that covers what your screening program is about, who it affects, and essentially when it goes into, when you issue that policy to your employees. On the other side of it, you definitely don't want to jump to conclusions when you get your background check report and automatically disqualify someone just because they have a criminal record, for instance. So you want to make sure that you're carefully evaluating them. You're considering the nature and gravity of the offense, the nature of the job that they're applying for, and also the time that has passed since the offense or the offenses in question here. So, take it easy. Don't panic once you get that background check report. You really want to take a look at it and make sure it's relevant to the position that the candidate is applying for. Another important factor is that you not forget what's called adverse action procedures. And again, this is a requirement under the Fair Credit Reporting Act, which basically requires an employer that if you receive a report and that information in the report is potentially impacting your decision to move forward with the candidate, that there are some requirements for that employer to follow. And so kind of the three things that you need to provide as part of that pre-adverse action process is that you need to give the candidate a copy of their background check report, so they have a right to see that. And you need to provide them with notice that you potentially may not move forward with the candidate because of content in that background check report. And then you should also supply them with a copy of a document called the Summary of Rights under the Fair Credit Reporting Act. So those three items are really critical to provide as part of the pre-adverse action process. And it's definitely an area, again, where there has been some litigation, and you need to make sure that you're doing it if that circumstance occurs. You also don't want to single somebody out for a background check. You want to make sure that your program is relatively consistent for employees of a similar nature. And lastly, just make sure that you're not doing background checks on your own. You really want to make sure that you seek the support of a professional or legal counsel, because again, it's a highly litigious area, and it's important to make sure you have a good understanding of the do's and don'ts. We're really only covering such a small portion of that today. There's so much more to consider. So take it easy and abide by some of these basics.
Well, great, thank you. These are really good do's and don'ts that all employers should definitely follow. So, all right. What would you consider the basic foundational search elements of a screening program?
Sure, yeah. This term background check or background screening program, it's really a generic term. So employers really need to take steps to start to translate that into specific background check search types. And I work with many employers, that are just getting started, or they're working on improving their program. And so these are just kind of a couple searches that are great foundation and areas that you want to focus on. So first, I would definitely recommend what's called the multi-jurisdiction criminal search. And despite popular belief, there's no national all-inclusive database of criminal information. And, I'm familiar with the TV shows that may depict that. I know there's also a lot of marketing ploys that some background check companies can use, which indicate that, hey, do this and you don't have to do anything else. And it really, there's no national database. It doesn't exist for this type of purpose. So, but there are powerful, they are powerful data tools that scan thousands of data sources and can scan millions of records. But by nature, they also can omit a significant amount of data as well. So, the multi-jurisdiction is a great tool for broad coverage, but, if you're using it, you just want to be aware of the limitations of it as well. So, but again, it's still highly recommended as a critical or foundational element of a screening program. The next item is, again, there are different names for it, but a social security or past address trace. This is an investigative research tool that basically identifies name variations or AKAs on a person, and then it also helps define the scope of your criminal searches. So it helps you identify these other names and locations that are connected to that individual, which usually is what helps those localized criminal searches. And those can be called statewide criminal searches or county criminal searches. And again, those are more focused criminal records in specific jurisdictions. So you kind of use those tools together to define the scope of the investigation. Beyond that, there could also be some other types of searches, which are usually more position specific, and that could be something like an academic verification, an employment verification, driving records, credit checks. Those are all things that usually an employer will look at a candidate and determine whether these records should be reviewed as well. So it's kind of all those things together that make the foundation of your screening program.
Well, great. Thank you. This, I know a lot of our clients ask, what basically goes into a successful, background screen. So this is very helpful. Thank you.
Sure.
Earlier, you mentioned disclosure and authorization forms as an area that's important for employers. So what are some of the guidelines that background check disclosures should include or actually exclude?
Yeah, no, this is definitely an important area to consider. And the FTC actually recently issued an article on the content of disclosure and authorization forms. And at this point, there are so many versions that are available that have been created by attorneys and by employers. And so there's wide variation in the content of these forms. And as such, it's actually become kind of a hot area for litigation. So some of the key takeaways of the FTC's article is that you want to make sure you're keeping it much more clear and conspicuous. The actual document itself should not be buried in an employment application, for instance. It really needs to be upfront to the candidate what it is, what type of document it is, and what they're essentially authorizing you to do. Beyond that, you definitely want to make sure that you're removing some things from old forms that you may have. So look for any language that has like indemnification verbiage, hold harmless clauses, release of liability. Those types of statements you'll want to take out of a disclosure and authorization form. If you do have one that you're currently using, again, you'll want to take out language that references that. Also, to remove any certifications in it that your job application is true or accurate, any type of acknowledgement that your hiring decisions are based on a legitimate, non-discriminatory practices, take that out. And really what they're asking you to do is to keep those disclosure and authorizations short and simple. There is some technical FCRA language that is still necessary to be in it so that you are still disclosing the nature and scope of the investigation. But again, you just want to remove anything that is considered extraneous or overly broad. Those types of statements can get the employer in hot water. So again, these are just kind of some basics, but as always, it's best to consult with your legal counsel on the content of your background check and authorization form.
All right, great, very helpful. I'd like to go now to drug screening. So, what can you tell us about drug screening? And also, very common question, very common area that a lot of, especially small employers, are discussing with us about is marijuana and what are the requirements, what can and can't you do in Connecticut, et cetera. So if you could tell us a little bit about drug screening and also the impact of that marijuana has on employers.
Sure. Yeah, and you hit the nail on the head with marijuana being the main focus. It's, drug testing is really a hot topic, and there are been overwhelming changes in the area of marijuana specifically. So it's becoming increasingly difficult for employers to, decide what it is that they need to do in their state, in any state that they do business with. And it's so important to monitor this area because it really is changing day to day at this point. So some basics to understand is that marijuana continues to be illegal at the federal level. It is still listed as a Schedule I drug, which according to the government means that there are no medically currently accepted medical use, and it has a high potential for abuse. So still maintains the Schedule I drug list. But as we know, it has gained popularity amongst many states. At this point in Connecticut, which is where I know a lot of your clients may be located in, Connecticut itself has decriminalized it, which basically means that there is no prison time or criminal record for first-time possession of small amounts. You can kind of think of it as a minor traffic violation here in Connecticut. And then if, there is possession of 1/2 ounce or less, it's basically a civil penalty with a fine. If you've got more than 1/2 ounce, it's considered a misdemeanor, and they can, fine you up to $2,000 and up to a year in jail. But, again, overall, it has been decriminalized. In Connecticut, there is also a medical marijuana program known as PUMA, which is Connecticut's Palliative Use of Marijuana Act. And this went into effect in 2012, and in 2016 it was expanded to include additional things that people can be eligible to take medical marijuana for. So, as an employer, you should be familiar with what Connecticut's requirements are there as well. And a lot of the questions that really, we have received as a background check company is, I have a positive test. What do I do now? And, positive tests, really, they just have to be evaluated carefully. And, whether it's recreational or medicinal positive test, still very important to consult with legal counsel, because a positive test is not, what has once been an automatic disqualifier. It's really not anymore. And so if somebody is positive, it still may mean that they, can and should be employed by your company. So it really requires that careful review of the position and what the circumstances are to determine if they should or should not move forward with the hiring process. So we have seen some requests from clients saying, if I'm going to hire them anyway, why do we even screen for marijuana? And that's a valid point. So we've kind of seen this trend of employers removing marijuana from their drug testing panels. So, maybe if they test positive for other areas, then it would prohibit them from moving forward. But, it really, again, it depends, and you have to conduct this careful evaluation. The other thing I did want to point out is to make sure that we're talking about, at this point, non-regulated employers. So if you do have something like, DOT mandates and things like that, those programs really should be handled differently. But the non-DOT space, these are some main points. DOT, again, has very different requirements. So, but nonetheless, it has become a changing area, and, you just have to continue to look at it on a case-by-case basis.
All right. Well, great. Thank you. Yes, this is as you said earlier, this is definitely a hot topic, and in Connecticut, with the confusion that, yes, even though it is decriminalized, it is still not completely legal in larger amounts. So
Right.
other
Right.
than for medicinal purposes. So thank you.
Right.
Okay. Can you take a brief, a minute or two, take a little bit of time and kind of give us some industry-wide trends in background screening? What are you seeing? What changes? What additional information, especially for that small to mid-sized employer that we do a lot of work with? What are some of those trends that you can communicate to us today?
Sure. Yeah, I think technology is probably the biggest area that has influenced change in the background screening arena. And some of the, I guess, positive impacts of that is that, generally speaking, the turnaround times to receive your results have gotten better, meaning that your results are coming back quicker. And that's often due to the fact that there's more data sources that have become electronic. Integrations have become very common. So information is going back and forth between researchers and courts and background check companies much more seamlessly than they have in the past. So hopefully you're experiencing better times to get those shorter periods of time to get your background check results. And, just to hone in on that integrations for a second, I mean, there has been such tremendous amount of change in the HR technology world. Applicant tracking systems, human resource information systems. Again, the plug-in between background check companies and those types of platforms are happening very commonly, very rapidly. So that's a really good thing, because it helps reduce some of the data entry needed for background checks. Accuracy, all those things are improved when you have information shifting quicker and more easily between the parties involved in the process. And the other thing I think is important to discuss is that the frequency of when background checks are done has also kind of changed. And our industry used to be, employers were really focused on conducting a background check, at the time somebody's being hired, known kind of as a pre-employment background check. And so now what we're seeing is that these background checks are happening on much more regular frequency. So it could be, every couple months, it could be annually. And so those are happening so that you're monitoring your employees getting, making sure that nothing has happened during the course of their employment. And the next phase that, again, is becoming more popular is that we're moving even away from regular frequencies, and there are tools out there now for continuous monitoring, which is basically there's some tools that can alert employers that if somebody was arrested and, a person was arrested at one of the qualifying jails and that booking was recorded electronically, that there's an alert that can go back to your employer indicating that an arrest has taken place. So again, we're kind of moved from this reactive approach that, pre-employment or on some frequency to, at the time something is happening or within a couple hours, a day or so, an employer can get an alert that, an arrest took place. And so that is still developing. There's still a lot of, again, legalities that need to be worked out there. But, as we talk about trends, that's the direction that we're heading in. So gaining popularity, and more tools are becoming available for background check companies and employers to consider. So yeah, I would say, that's what's up and coming.
Oh, well, great. Well, thank you. And thank you for being with us. This is very worthwhile. You've covered some critical components and some interesting trends in background screening and what employers definitely should be aware of. So thank you very much, Maribeth, for joining us.
Yes, and thank you for having me.
All right, that's great. And thank you all for listening to this KardasLarson HR Chat. We encourage you to follow KardasLarson to receive information on future webinars, compliance updates, and our speaking engagements. Thank you again.